Welcome to Health Law Talk, presented by Shahardy Sherman Williams. Health law broken down through expert discussion, real client issues, and real-life experiences. Breaking barriers to understanding complex healthcare issues is our job.
And good morning, everyone. Again, 2022, our first real podcast in 2022. Conrad Meyer here with Rory Bellina, Chris Martin for another episode of Health Law Talk. Good morning, guys.
Good morning, everybody.
Good morning.
And again, today, very interesting topics that we have because things are moving at lightning speed in the healthcare world. But we're back to COVID vaccine mandates and specifically the Supreme Court rulings on two different challenges to the COVID vaccine mandates. One was a challenge with respect to the conditions of participation that was issued by CMS, and the other one, the more well-known one because it was all over the news, right, guys? The OSHA 100 employee mandate.
Correct. So I think those were the two that were challenged. I believe the federal mandate, that one is currently being challenged. So we'll definitely do an update on that as that progresses. I believe it's been stayed in some states, but let's jump right in. And I think we could talk first about the CMS mandate. And,
right.
If you're looking at was it upheld or not, this was the one that was upheld. We're also going to talk about the OSHA private employer mandate. That one was the one that was essentially struck down. So, like a little bit of a background for this one. So this is the one where a few states sued. They named the president in the lawsuit. Obviously, the named state was Missouri in this one, and also Health of Human Services. This one was all involving CMS, and the government's argument was that they were allowed to make a condition of participation. Health and Human Services were for if you were a participating provider as a condition of participation, essentially, and there's a bunch of more details to it, but the broad gist is that as that condition, you would have to mandate your employees in the healthcare setting to be vaccinated. And I know on a previous episode we talked about, well, who's an employee, who does it apply to, who does it not. We don't have to get into that today, but that was a requirement, and kind of we always talked about the carrot and the stick. The stick was that we could yank your participation from CMS, and those dollars would stop flowing to you.
But before we get into that, I think, for those of you who maybe have not listened to the previous podcast, I think it would be important for us to describe what is a condition of participation so our listeners will know why that is so important to especially Medicare, Medicaid participating providers.
Yeah, I'll give the definition, but then we could kind of jump into what it
Right.
actually looks like on a day-to-day basis. But it's very broad. Congress authorizes Secretary of Health and Human Services. Basically, they're allowed to do conditions that would requirements as found necessary in the interest of health and safety of individuals who are furnished services in the institution. So what does that mean?
So in other words, in order to see Medicare or Medicaid patients, providers have to do certain things. They're required to do that to participate in that. Is that it?
Correct. And we're always looking at what those conditions of participation are. I know, Chris, you have a few in mind that you can describe.
I can. The idea, too, just in the way I think about it is the federal government says, look, if we're going to be paying for services, we have the right to, just like sort of our taxing authority, we have the right to say you have to comply with these various requirements in order to get our money. And so that's the idea behind conditions of participation, such as certain fire and safety requirements. Certain operating rooms have to be a certain size. So there's physical requirements, there's health requirements. And I think the Supreme Court kind of said, this is kind of a no-brainer. If hospitals are supposed to keep people healthy and their employees have the opportunity or the prospect of infecting patients because they're not vaccinated, it's reasonable to require healthcare workers to be vaccinated.
And I think in this case, the justification was already there because Congress has already authorized the secretary to impose the conditions. And I'll again quote the language that the Secretary finds necessary in the interest of health and safety of individuals who are furnished services. So that's as broad as we want everyone that's in a hospital setting to wear gloves when they treat a patient, wear head coverings if they're in surgery. It can get very specific, but it's just very broad health and safety measures. I know, Conrad, you're familiar with those as well.
Yeah, I mean, this is interesting, Tim, because this is a second bite at the apple that has been taken, targeted at healthcare workers, because OSHA issued its first ETS in June of last year, and now we've got CMS coming in on if that doesn't work, well, here we're going to make it a condition of participation that you have to have this vaccine.
Correct.
So, it was a double whammy, and I saw when I read the ruling. It was very interesting because it all made sense. For example, I know that my significant other, for example, is a healthcare worker. So before she can step foot in the hospitals, they have to have certain vaccines, certain things done, and otherwise they can't walk in. So why not have COVID?
And there's protocols in place where if she does surgery or touches a patient,
absolutely
those steps as well, and
universal precautions. You have certain and how to dispose things, how to store things.
And I think some employees, especially in a healthcare setting, might realize, well, that's just my hospital making those rules. It's really not. It's coming from the top down.
Yes.
As far as those, and those are conditions of participation. And I think that again, it talks about. So I'm reading through the ruling from the Supreme Court and pulling some quotes. One thing it says, one of the most pertinent parts here is programs that hospitals must implement to govern the surveillance, prevention, and control of infectious diseases. Mm-hmm. So that's a very broad condition of participation. So surveillance, prevention, and control of infectious diseases.
So what is that? Like a TB test. You have to have your TB test. You have to have your flu vaccine. All those things I know that a lot of healthcare workers must have.
Correct.
So if those are okay, right? If that's okay if it's okay to mandate those vaccines, then why not COVID?
And I think that's exactly what the Supreme Court thought. And I know we get the question. Some employees, question, why do I have to do this at this level? And again, it comes from maybe not your hospital system, but it's coming directly from CMS.
Interesting. It was really. I mean, I got to tell you, when I was watching when I was listening to the hearing, and I was listening on this particular one with respect to the CMS ruling, I kept thinking in my head, like, it doesn't make any sense. Like, in other words, the arguments that were against it, I felt. I mean, it were good arguments, but I didn't think they held water because of if you can mandate one, why can't you mandate as far as a healthcare worker?
And that was actually quoted in the Supreme Court decision on this.
Really?
The question came up when asked at oral argument whether the Secretary could, using the very same statutory authorities at issues here, require hospital employees to wear gloves, sterilize instruments, wash their hands in a certain way and at certain intervals. Missouri, which was the state essentially that came forward against this, they answered yes. They said, of course they could. So I felt at that point, everyone on the bench probably sat back and thought, well, there we go.
There we go.
Here it is. If that's a yes, how is adding another vaccine to the already litany of requirements and vaccinations that healthcare workers have to get?
And you know what the sad thing is? I would have felt like a pit in my stomach if I was the lawyer, right, challenging this rule. Because you're like, okay, I think I just lost.
I thought substantively that this was the right result, but I wasn't sure procedurally that the Supreme Court was going to allow this to go forward because of the notice and comment. The Secretary had avoided the notice and comment period.
And that was brought up in the dissent. It wasn't brought up in the majority opinion, but that was brought up in the dissent, and I believe the dissent had an issue with how that period was shortened.
So for the listeners, because we understand what that means. So for listeners, notice and comment means that if an agency wants to propose a regulation, like for example a vaccine, and correct me if I'm wrong, guys, if they want to propose a regulation for a mandate or whatever they want to propose, they have to do a proposed rule, allow a specific amount of time for comment. And then after that, they do a final rule where they've taken the comments into consideration and responded to each of the comments that were submitted. And then after the final rule is issued, there's usually some sort of a final correction or correction period after that.
Correct. The interim final rule, yes.
So if you bypass all of that, right, which is what happened here, then have you procedurally circumvented due process, or I guess whatever that.
And that was the dissent. That was a big part in the dissent on this decision, and it's kind of glossed over in the majority opinion. But the thought was, we have to do this, and we have to do this fast, because in any other industry, the healthcare system and setting is the most important thing that gets. That stays operational. This is not. I'm sure the Supreme Court would never say this, but if a retail store had to close because all their employees had COVID and no one could go in and buy the widgets that they sold, probably not detrimental to the country. But if huge hospital systems have to shut down because they have unvaccinated employees who are spreading or showing more severe symptoms, that's a drain on a much larger area and population as a whole. And I think that's why the majority in this decision was okay with speeding past all the comment periods.
Right.
The other argument that I don't think the majority commented too much on was these original lawsuits, I think, were brought primarily by rural states that have trouble staffing hospitals.
Right.
And the argument was, if you mandate this, we're going to have a bunch of healthcare workers quit, and we're going to be in the same fix of not having enough people to actually provide services to sick patients. And I'm not sure that
did that happen? I mean, have we seen the
it was
fallout?
brought up. That comment was brought up in the oral arguments. I remember they cited some statistics on how many people they thought would leave the healthcare workforce if they were forced to be vaccinated. And I know Justice Breyer was the one who really got deep on this and asked the attorney for Health and Human Services, and they said that they have people to replace them, or that was their position at least.
Mm-hmm. I'm wondering if we're going to start seeing the nurses do what the truckers are doing in Canada right now, and having massive boycotts, across the country.
And it's tough to tell. I think it's so, one thing that comes into play is being a nurse or healthcare provider or physician, whoever it may be, you've spent your life training for this, time, money, resources, effort. If this is something you feel strongly about, yes, you're going to walk away. But I think in this case, and this was a little bit hinted on in the oral arguments, if anyone listened to them, it was a little bit hinted on that they don't think that those people are really going to walk. They think that kind of a bluff almost, that they're really not going to walk away, that they've dedicated their life to health and public service, and they knew getting into this that they were required to get vaccines. It's just that this is a new one that has been very politicized, and they
but
might
when's
not
the
want
due date for this? So this is upheld. So when is this supposed to go into effect? Do we know? Do y'all know?
I think the first.
I don't know the answer to that.
I think the first shot has to be done by middle of February.
Okay.
And the second shot has to be complete by the middle of March.
Got it. Okay.
So they extended they redefined those deadlines in light of this opinion and gave the hospitals more time to comply.
Well, hopefully we won't see a nursing shortage in the rural areas, because I know rural hospitals are desperately needed in terms of access. So hopefully that doesn't happen.
Yep. So like we said, and I'm just going through the dissent. Justice Thomas wrote the dissent on this one, and then there's other dissents written as well. But the majority issue that they had was not really with the actual policy itself. It was more of the procedure, like you mentioned, Chris, which I think that's fair. I mean, that's a way to definitely knock down rules that are made. But I mean, you'd have to ask the justices off the record, did you have an issue with the policy or with the procedure? And I think they would probably say we had no issue. I'm speculating. We had no issue with the policy. It was more of the procedure, which is just as valuable as a position to take.
Very interesting ruling. At least it fell in line with a lot of things that I think we would have expected. So
Yep.
Interesting.
So this one, like Chris said, the first shot, and that's fairly approaching. And I don't expect to see much more out of this one now. I think that CMS,
it's done, right?
Yeah,
I mean, it's
CMS
done.
knows their powers. I think hospital systems know their powers, and this one's done. So
I just want to know how they're going to enforce it or look at. I know hospitals do an attestation, meaning they attest that all their employees are vaccinated. But what do? Do you go and say, show me all you go to HR and say, give me every employee record, and you go through an audit, I guess? I
think it's going to become similar to how hospital systems, I know, both of you were with hospital systems, Chris and Conrad. I assume it's going to be, they've got software to track this, but okay, Conrad, does he have his vaccination? And they get a report of the employees that do or don't, and they're going to have to track that, just how they have to track, did you do your first aid training? Did you get your annual flu vaccine? I think it's just going to be one thing added to it.
When I was at Oxnard and they mandated the flu shot, they actually put a sticker on your ID.
For the badge.
On your badge saying you've had the flu shot. So you literally would walk around and you either had it or not, but somebody could actually see.
Maybe they have a sticker that says I'm got my COVID vaccine or something.
Yeah.
I don't know.
Yeah.
Well, we have another ruling now we have to go over. I think this is the bigger.
This is the bigger one as far as millions of Americans that it affects. I believe the estimate was 84 million Americans. But
that's right.
We're going to take a pivot now and talk about the OSHA private employer one. So if you're keeping track, this is the one that was struck down as most recently as last week. The government, or OSHA, removed it from the Federal Register. It kind of just went away overnight, but we want to give some information. So, Chris, I know you want to kick us off on that one.
Yes. So, this was the OSHA vaccination mandate that required either all 84 million employees be vaccinated or tested weekly.
And wear face coverings. And there were a lot of other stipulations involved with the testing. That you would have to essentially, your employer did not have to pay for the weekly testing. They didn't have to give you time off to go get weekly tested. This one had a big burden involved. And I think the Supreme Court really weighed in on that.
And it applied to only employers that had 100 or more employees in the private sector. And the interesting thing about this opinion to me was the word they italicized the word occupational safety like 5 or 6 times.
That was a big key phrase, and I remember that even came up in the oral arguments. And occupational safety.
And the distinction they made there is OSHA's tasked with ensuring occupational safety, not overall public health.
Right.
And one thing that they did, I know that they even brought up what occupational safety looks like. So for anyone that's been regulated by OSHA, I know that both of you had experiences with the system, but OSHA, if you're on a construction site, some examples of occupational safety would be you have to wear a harness if you're above a certain height, you have to wear hard hats, work gloves, eye protection if you're doing certain things. So again, occupational safety. And Chris, what was the comment that was mentioned in this about bringing this home? There was a big talk about bringing it home by the Supreme Court justices, and they went back and forth.
Even in the arguments, because when I listened to the arguments, this was a big deal.
About bringing home the vaccine versus bringing home the hard hat. If y'all want to elaborate on that?
Chris.
Yeah, it was the idea was that here's the quote: a vaccination, after all, quote, cannot be undone at the end of the workday. So you can take the hard hat off, you can take the gloves off, you can take the goggles off, but once you're vaccinated, it's more permanent.
So the justices in this case made a kind of a hard line and said, you go to work, you might not want to wear a hard hat, you might not want to wear safety glasses, but you need to do it to be safe on your job.
At work.
But then as soon as you leave, if you don't want to wear a hat anymore or safety glasses, you could take those off because you're not at work. With the vaccine, once it's in you, it's in you.
Yeah, I mean, it was a far overreach, by OSHA to do this, according to the court, and it basically said that in all of its existence, it had only made such a demand like this 9 previous times, and of those 9, I think a good majority of them were struck down.
I think it was they had been challenged 6 or 7 times,
and a majority of those were struck,
and only 1 had been upheld in full.
So this was even more of a reach. And I think the quote, like you said, was occupational. While you're at work,
correct.
It's not a public health agency. Its job is not to mandate public health.
Correct. Correct.
And I thought that was a great analysis. And I know a lot of people were upset about that. There were a lot of people who were not happy about the ruling, but I think it was the correct ruling.
And towards the end of the majority opinion for this one, Supreme Court kind of gave a little nugget or a little token for how OSHA could come back and take another bite at this. If either you want to talk about that in regards to, they talked about physical spacing and requirements. And I mean, I read it to read. They said, OSHA, this isn't the proper way to do it if you're concerned about COVID.
Well, I mean, correct me if I'm wrong. So, and I know, Chris, you have it in your hand right there. So, correct me if I'm wrong. The comment was it was a very broadly written, overbroad, and vague rule.
Yes.
They said they discussed, I think, specifically, for example, landscapers and landscapers who are not inside or not in a confined space. How does that apply to them?
Mm-hmm. But if they went to a meeting once, ever inside,
correct,
then they would fall under this.
Right. So the way I read it is if OSHA came back and suddenly said, okay, for each individual industry, here's how we're going to apply the COVID vaccine, that in and of itself might be different.
That's right.
And I think they mentioned spacing in the oral arguments that came up in it. I think it's, Chris, you have the language.
Yeah, I'll just read it because it's well written and it's clear. It says, this is not to say that OSHA lacks authority to regulate occupation-specific risks related to COVID-19, where the virus poses a special danger because of the particular features of an employee's job or workplace. Targeted regulations are plainly permissible. We have no doubt, for example, OSHA could regulate researchers who work with COVID-19 viruses. Mm-hmm. So too could OSHA regulate risks associated with working in particularly crowded or cramped environments. But OSHA's indiscriminate approach fails to account for this crucial distinction between occupational risk and risks more generally, and accordingly, the mandate takes on the character of a general public health measure rather than an occupational safety or health standard.
So some of the commentary that came out after the decision was written, I read the commentary based on this as well, and a lot of the commentary was that the government thought that OSHA was the right mechanism to reach the most Americans to get this in place, and the Supreme Court said, well, that's correct, but this is too broad. You're making this has nothing to do with occupational hazards.
But is it really for most Americans? I mean, that's exactly what you said. I mean, they're taking on the role of public health.
Correct.
So I guess the question becomes: are we going to see a new set of regulations set forth by industry at this point? Do you think OSHA's going to come back?
I think that if they were to come back, like Chris mentioned and like the Supreme Court mentioned in their opinion, it would need to be industry specific and
so narrowly focused. If you were in a factory of 100 or more people and you are not physically spaced more than 6 feet, and I think if they came back with very strict criteria that gave the industry the option to fix. So let's talk about the example of the factory where everyone's on an assembly line very close together. I think OSHA can come back and say it's an occupational hazard. This is my opinion. It's an occupational hazard for employees to be this close together on an assembly line if they're not vaccinated, and if they're not vaccinated, if they're not masked, and weekly tests. But that gives you the option as the owner of the assembly line to add in partitions to space people out. Is that practical? Probably not. Right.
But I think it gives you the option. In this case, there was no option. It was vaccinate or weekly test and wear a mask. It didn't give you the option to spread people out or to put up partitions. I think that is what the Supreme Court is saying. OSHA, here's how to go back and do it again. Mm-hmm. That's just my opinion. I could be completely wrong.
I listened to the oral argument on this, and I forget which, it was Breyer or Sotomayor or Kagan. I think it was one of the two lady justices. They kept saying this is not a mandate.
They did. They kept on saying it was not a mandate. You can wear a mask and test weekly. That was their. They
kept correcting the lawyers who would say mandate, and she would say this is not a mandate. You have a choice. If you don't want to get vaccinated, you can get tested every week. That's not a mandate.
Yeah, but they shift the risk on the employee because now the employee is going to pay for it, and they got to go every 3 days. I mean, it's totally overburdensome. Totally. Yeah, and I'm not going to get even. I won't even get into the science of whether or not masks work.
Sure.
Which we all have our own opinions about that.
Sure.
And plexiglass, 6 feet apart, if that really makes a difference. I mean, and then does vaccines even prevent you from getting the virus? So we can't get in there. But I agree, that I thought the ruling was the appropriate one because of the broad brush.
Well, in the first paragraph of the per curiam, it sort of captured it. It says OSHA has never before imposed such a mandate. I mean, you don't usually hear the Supreme Court say words like never or always.
Not that strong.
Then the next sentence I thought was even more interesting. Nor has Congress.
Yeah.
So not only you're giving all this power to this regulatory agency that nobody elects, nobody knows, or very few people know.
Right.
And we haven't, Congress, who's our elected representatives, have never passed such a strenuous, very broad mandate.
And those questions did come up in the oral arguments. The more conservative justices that wrote for the majority in this opinion were asking those questions.
Right.
When has this been done in the past? Give us examples.
It hasn't.
And
That's
they
the
went.
thing. It hasn't.
Well, they had to go into the ones that were done, but then that failed. That we mentioned.
Yeah.
I think there were 9, 6 were challenged, and I think 1 was upheld. They had to go into that. So it was interesting. I think that was a big factor in the majority decision. Those justices are more conservative, but they also like to look and see, has this been done before? Is there some sort of precedent for this? The minority in here, they were okay with doing something new.
So I think we've come full circle now on this. I mean, we've done podcasts on this topic before. All of us have sat in this room and talked about it.
And there's only one left, the federal employee one, the truck driver one, as a lot of people deem it. That we're waiting to see what happens with that.
But I guess my question to y'all is to both of you is: are we going to see this come back at us? So is Congress going to say, you know what? Like throwing a temper tantrum. I don't like what they did, so here's another one. Or here's the president. You know what? I don't like this, so here's another one. He'll direct an agency to do another one. Are we going to have this back and forth between the executive branch versus the agency versus the state AGs, and we're back at the Supremes?
We're going to shift from Health Law Talk podcast to now Political Talk podcast.
Well, I mean, it's very applicable.
It is.
It is very applicable.
My personal, unofficial opinion is that CMS.
That's worth a lot. Same with mine.
CMS is done. I don't think we see OSHA come back. I think that the Biden administration took a loss on this.
Right.
And midterms are approaching. The president's popularity has gone down. I think that it would be too much collateral damage. I think they're just gonna
lick their wounds,
move on. Hopefully, Omicron was one of the last big variants, and I think they see that people are more voluntarily getting vaccinated. I think that I don't see the Biden administration pushing for another bite at this apple. That's if I had to bet on it, that would be my bet.
And if you kind of look at how the administration has pivoted after these rulings, they now are releasing 500 million masks. They're now making it easier to get vaccinated by insurance coverage.
Free at-home testing delivered by the post office with the at-home test. I agree.
That's kind of how they've changed their tactics.
You know where those tests are made, right? Yeah,
that's another podcast. That's another podcast. But that's a really good point, Chris. That the vaccine challenges. Let's say that they're done. They're shifting now to the masking and the testing. Right. That's a good point.
So are we going to somehow maybe hopefully follow the example of the UK or Denmark and say, enough of this, enough mandate, enough requirement. Let's just live with it and move on, and just that's the way it is. Are we almost at that point?
Well, I think it kind of depends on the virus to see. I mean, if there are other variants, they become less and less potent and less harmful, less fatal.
Are we going to run out of letters in the alphabet?
Well,
I think we're slowly getting to your point, Conrad. I think we're slowly getting to that part where I think we're slowly getting out of it. We're not getting out of it nearly as fast as anyone wants. Whether you like Dr. Fauci or not, his position is that we're still early into this and that we need to meet more hurdles. Some people believe that, some people don't. But I think politics is going to play a lot into how quick we get out of this. I think if there's a big shift in the midterms, I think that's going to accelerate us getting out of this faster. And I think after the midterms, which are coming up in this, like now we're going to politics, which I do love talking about.
It's okay, but you understand when you deal with regulation, you also deal with policy. So
correct.
You have no choice.
And after the midterms, that's right after the midterms are in November. They're sworn in I believe January.
Right.
That's kind of when the presidential election cycle is going to start kicking off. So I think that's when, depending on how all of that goes, midterms and who's going to run for president.
So in the interim, no more regulations. Wait to see the midterms.
I think the focus right now is going to be on midterms. I think we're really going political talk now. I think the focus is going to be on the Build Back Better plan, of the infrastructure plan that the president is trying to push forward. I think he's over policy making, personally, on the vaccine. I think, like Chris mentioned, really good point that I keep going back to is giving out free tests, giving out masks. We're kind of seeing it here on a local level in the state of Louisiana. We all thought our governor was going to re-implement a mask mandate in Louisiana, and every week he comes out and just updates everybody and says, please wear one, please social distance. But I think there's kind of being a shift of, hopefully, no more mandates, but we're going to just have some personal responsibility now.
Well, I think also people are getting numb to it. I think people are like, you know what, we've kind of had enough. And so
we're going on 2 years.
2 years. And so
and at this point, most people have, if you've done your part, if you were going to get vaccinated, you probably would have already done it by now.
Right. And look, I'm not bashing the whole politic thing, but I mean, when you start talking about healthcare regulation, you can't get away from policy.
You can't.
And policy involves politics.
Correct.
So, I know normally we try to avoid the long, drawn-out political discussions on the show, but I think in this particular case, because of the continued recurrence and the importance of the Supreme Court rulings, I think it was necessary.
The last thing on the Supreme Court was, to me, it was very interesting how quickly the Supreme Court acted. They don't typically
hear cases that
fast, and then
they issue the written ruling. I mean, that was quick.
To hear the argument,
2 weeks or a week and a half.
Not even that. I mean, I'm sure they were writing it right after they left the bench.
It was very fast.
So it was extremely fast.
Yeah.
Wow.
I think a lot of it, like I said, I think there's a bigger political angle in all of this.
But you know what? Good for the Supreme Court for it settled the issue, Chris. Good for the Supreme Court to recognize that we have a challenge clear here to review. This is going to set the direction of the country, and they did it quickly and thoroughly.
And I know we're kind of going backwards now, but what was the vote on the CMS? Was it 5-4? I believe it was 5-4 with Kavanaugh possibly in the majority on this one, or was it?
I don't remember the
Roberts, but it was close. It was close.
Was it on OSHA 6-3?
I think OSHA was 6-3 with all the conservative justices voting in favor, but I believe it was Kavanaugh that voted with the more liberal justices on the CMS mandate, which I thought was interesting. But at least that's what they're there for, and he thought that it met the requirements. So, and we're gonna have a new justice this summer, so we'll see what happens.
We're gonna see how that goes down. All right, guys, that was a great episode here. We really appreciate everybody listening to the show. That was another episode, the first 2022 episode of Health Law Talk with Shahardi Sherman-Williams. Please make sure you subscribe to our channel. And if you have any comments or feedback, or if you have any topics you want us to discuss, please make sure you drop us an email. We always look forward to comments and suggestions. So with that being said, look forward to another podcast coming out soon, headed your way on Health Law Talk.
Thanks for listening to this episode of Health Law Talk, presented by Shahardi Sherman-Williams. Please be sure to subscribe to our channel, make sure to give us that 5-star rating, and share with your friends. Shahardi Sherman-Williams is providing this podcast as a public service. This podcast is for educational purposes only. This podcast does not constitute legal advice, nor does this podcast establish an attorney-client relationship. Reference to any specific product or entity does not count as an endorsement or recommendation by Shahardi Sherman-Williams. The views expressed by guests on the show are their own, and their appearance does not imply an endorsement of them or their entity that they represent. Remember, please consult an attorney for your specific legal issues.